Good day and welcome to the review of chapters 15 and 16, Gender and Age Discrimination. We have already covered much of the content, but our author, Charles Fleischer, brings a legal perspective that is most helpful when dealing with these types of discrimination. The Equal Pay Act prohibits employers from paying men and women at different rates for the same work unless the differential is based on a factor other than their gender. For example, a higher degree or more experience. The Pregnancy Discrimination Act is an amendment of Title VII. Included under PDA are women affected by pregnancy, childbirth, or related medical conditions. Those under PDA should be treated for employment-related purposes like any other employee, similar in their ability or inability to work. As our author says, discrimination because of pregnancy, childbirth, or a related medical condition is sex discrimination. An employer cannot refuse to hire a pregnant woman or a woman of childbearing age because of the possibility that she may become pregnant. Also, employers cannot force pregnant women to take leave at a specified point in their pregnancies. The exception to that is if an employer can prove a bona fide occupational qualification, which is a decision deemed necessary for the normal operation of the business. Companies are also required to hold a woman's job for when the mother returns. Under FMLA and state laws, however, employers are not legally required to grant paternity leave. Please read over the sections in our text called Harassment in General and Hostile Environment. Paramour preference occurs when a supervisor is romantically involved with a subordinate. Because of the relationship, the employee receives more favorable treatment than other employees. Although this relationship may be inappropriate, the courts have rejected claims of paramour preference, saying it does not amount to sex discrimination. A tangible employment action is defined as a significant change in employment status, usually resulting in economic injury, such as a firing or a failure to promote. Employers can be held liable for such as it can create a hostile work environment. Please remember that workplace sexual harassment does not just occur from a supervisor to a subordinate. The employer can be held liable for tolerating a hostile work environment caused by a coworker or even a customer. There is an extensive list of protective policies in our text that includes do's and don'ts to protect employers from sexual harassment claims. Please read over. In 2020, the Supreme Court held that it is unlawful to discriminate against an individual for being homosexual or transgender. You can also see a list of other court cases that show, as our author states, a remarkable social movement that revolutionized traditional codes of behavior related to sexuality and interpersonal relationships. Please read over the section entitled Other Issues, which include dress codes, retirement plans, and physique. In looking at the Federal Age Discrimination in Employment Act, the purpose is to promote the employment of older persons based on their ability rather than age by prohibiting age-based discrimination against employees and those who apply for jobs. The ADEA applies to persons 40 and over. Say I am a hiring manager and I have two candidates, a 35-year-old and a 45-year-old. Because of ADEA, am I required to hire the 45-year-old? Well, if I use objective, job-related, non-discriminatory criteria and I choose the 35-year-old candidate, that is not an example of age discrimination. When making personnel decisions, our author cautions us from using terms like dead wood or wanting some fresh faces or new blood. Those can be looked at as evidence of age discrimination. The ADEA covers most employers with 20 or more employees. The coverage provision tracks Title VII, except with Title VII, that is for 15 or more employees, whereas ADEA covers 20 or more. There are a few exceptions for ADEA. One that we've already mentioned is a bona fide occupational qualification. Our text gives us the example of airlines requiring pilots to retire at age 60. The FAA also had that rule, but Congress has raised the age to 65. Proving age discrimination can be difficult. Please read over the section called Proving Age Discrimination and Release of ADEA Claims. This concludes our review of the Gender and Age Discrimination chapters. Have a wonderful day.